Welcome back to the second segment on this law session in relation to judicial review in public law. Now, before the break, I said you would come back and look at the conditions which are necessary in order to bring JR proceedings. Now, I said that the first thing to consider is whether or not the issue at stake is a public or private issue, because the areas in which the dispute arise must concern public law. It cannot be a private law issue. Now, this is known as the exclusivity principle, and judicial review cannot be used as a substitute for legal proceedings which involve disputes in which there arises no issues of public law. The point being that you cannot use JR as another way of bringing an action, because JR is kind of like the last line of defense. That being the case, you can't use it like you would an appeal, or you can't use it as some kind of action to do with a private matter. So there must be some issue of significant public law, or where the public law component of the claim is the main part of it. Now, the main case in this area, of course, is O'Reilly and McMahon in 1983. Now, the problems do exist where you look at matters or cases where you have both a private and a public law claim element, and this is where there can be some controversy. Now, this is a case where in the O'Reilly and McMahon, it did consider this controversial issue which has been debated a lot as it relates to this exclusivity principle. Now, the exclusivity principle was, of course, ventilated in O'Reilly and McMahon, and here the point was that a general rule was established which said that claims for declarations or injunctions relating essentially to public law matters may only be pursued via the special procedure which is laid down in Order 53 of the Rules of the Supreme Court Administration of Justice Act 1981 under Section 31. The point is that Order 53 contains significant procedural protection for authorities, such as time limits and also requirements of leave, which cannot be said, for example, the writ procedure where you're looking at a private matter. Now, the case of O'Reilly has been criticized by many academics. However, there have been certain comments made about the case. Now, what is the case about? Well, in O'Reilly and McMahon, the plaintiffs had begun their action, which was to challenge their loss of remission as prisoners by means of a writ. Now, they started it by means of a writ rather than by an action for JR. And so what they had done was to sidestep the requirement for the action to be brought within strict time limits. The court said that the forfeiture of remission for a prisoner was, as a matter of law, not a loss of liberty, but a loss of privilege, the loss of right protected by public law. So they said any proceedings to enforce a public duty should not be by way of ordinary action. Now, Lord Diplock in the case said it would, in my view, as a general rule, be contrary to public policy and as such an abuse of the process of the court to permit a person seeking to establish that a decision of a public authority infringed rights to which he was entitled to protection under public law to proceed by way of an ordinary action, and by this means to then evade the provision of Order 53 for the protection of such authorities. The point, of course, in relation to O'Reilly and McMahon is when you look at Order 53, it sets up protections for public bodies precisely in situations where persons would need to bring JR. So the point is, if you're looking at a public law action, it really should be brought in relation to JR as opposed to private action. However, what we have seen, of course, is a massive criticism of this, and since that decision, the courts have indeed softened their approach to the so-called public and private law distinction, not least due to the difficulty with which you're able to define public and private. And we have seen in certain cases like the Crown and East Berkshire Health Authority, ex parte Walsh in 1985, it was decided that Order 53 is an inappropriate means of challenging a public authority when that authority is acting in the capacity of a private contractual party. This was also emphasized in the House of Lords decision in Roy and Kensington and Chelsea and Westminster Family Practitioner Committee in 1992, where it was said that the Order 53 procedures are only mandatory in cases involving purely public law issues. So it would seem that where there is a public and private law, the courts are not necessarily strictly saying that the public law issue must be significant, or in matters where it is jointly public and private. It is now seeming as if they're stepping away from that to say, if you're looking at a purely public law issue, that's when you're looking at the engagement of Order 53 procedures. Now, first requirement, is it a public law issue? Second, of course, then, is it against a public body? Now, public body needs to be defined. Now, we've touched on this in a previous law session, particularly when we look at Human Rights Act. We do see, for starters, that a court may be a public body. So arguably, you could JR a court in respect of how it came to its decision. Now, when you're looking at this requirement, you look at, for example, how public body has been defined in the case law. Now, the courts will look at whether the function that body performs are public law functions. In other words, whether they have consequences for public law. And it tends to follow a formulation where if the body in question did not exist, would the government, for example, have to assume responsibility for that particular action or framework? So when you look at the cases, it looks at this particular test. If that body didn't exist, would the government have to fill the breach? Well, when you look at the cases which have considered this, there are a couple of cases. First, of course, is RV City Panel of Takeovers and Mergers ex parte data fin. So in the ex parte data fin case, this was where the takeovers and mergers was considered, commission was considered to be a public body. So that panel was considered a public body, even though it had been established purely on a voluntary basis. Now, when you look at the RV Disciplinary Committee of the Jockey Club case, this is the ex parte Aga Khan case in 1993. When you looked at the relationship between the Jockey Club and horse owners, the courts considered that if it did not exist, if the Jockey Club did not exist, it was not something that the government would have to fill the breach on. By and large, it was said that that was a private situation, and as such, it was not considered a public body. So when you look at that requirement, it must meet the public body requirement. So in ex parte data fin, it did, and in ex parte Aga Khan, it didn't. The third condition that must be met, of course, is that the matter under consideration must be justiciable. Now, in order to apply for JR, it must be a public law issue which on its face, prima facie, is justiciable. Now, if you go back again, as I said, to a previous to a law session in public law that we looked at, for example, prerogative powers, we have looked at this issue of justiciability, meaning is it something that the court can consider in respect of its powers? So when we look at being justiciable, what we mean is that there are certain matters which are excluded from JR precisely because they're non-justiciable. Because, for example, they concern matters of, for example, high policy. So if you go back to, for example, the GCHQ case and how that was decided, the courts, first of all, because this was a matter in relation to JR, the courts considered first, did the prerogative power exist? Then it looked at second, how and what type of prerogative power was it? And when it considered it, it said, well, this particular prerogative power is one where it is a matter of high policy. And so the court said it was not justiciable, meaning it was not amenable to JR. In contrast, when you look at the case of M and the Home Office, we see that the courts again look at the question of, is it justiciable? And given the type of matter that was under consideration here to do with civil liberties and individual rights, the court considered that this was important to the extent that it was justiciable, and the courts were of the view that it could find that the Home Office needed to bring M back in order for his case to be heard. Now, there have been other cases, of course, the Laker Airways case, so Laker Airways and Department of Trade, and also ex parte Fire Brigades Union and others in 1995, where the court found that where Parliament had created a ministerial duty to act, it was no longer the minister's prerogative to exercise powers in the same area. So the point, of course, is when you're looking at this condition being satisfied, the necessity, of course, is to determine whether or not what is under consideration is justiciable. The next point, of course, is whether or not the person bringing the claim has standing. Does the person who is seeking JR, is he the correct person to in fact institute the proceedings? Now, the court must, of course, recognize the applicant as having standing. And this, of course, is the Latin expression locus standi. But since we're using clear language, we will go for standing. So does the applicant of locus standi, or does the applicant have standing? It means that the applicant must have what is considered a sufficient interest in the matter to which the application relates. And that requirement is set out under Section 31, subsection 3 of the Supreme Court Act 1981. Now, this is what is usually referred to as the sufficient interest test. And when you look at the cases, they do bear out whether or not the person does have sufficient interest. Now, if it concerns me personally, then yes, of course, straight away, automatically, I have standing. Where we have had some degree of problems, situations where you're looking at groups. So, for example, when you look at RV Inland Revenue Commissioners, ex parte National Federation of Self-Employed and Small Businesses, a 1982 case, the test is undertaken in 2 stages. The first thing to consider is when leave for JR is applied for, and second, during the JR proceedings itself. So an applicant may be seen as having sufficient interest at the first stage, but his or her application may of course be rejected later for not having sufficient interest. Now, this question of interest goes a little bit further. As I say, it looks at what happens when groups are seeking standing. Now, under this 4th condition, I will take a short break. We will pick up back with this 4th condition immediately after the break, when we will look at interest groups and we will look at pressure groups. What is the situation when a group is seeking JR or bringing JR proceedings on behalf of its members, for example? Immediately after this short break.